Cool. I just went on Tactical Sovereignty's Facebook page, and Brian posted famguardian.org. So in one of his, what was it called? Talk shoes, he talked about this invisible contracts, and he posted it in his group. So I thought I would read it. I know there's a young lady that has a baby, and I remember when I had a nursing child. It's kind of hard to, nurse at the same time as reading a piece of paper or getting on a computer. So let's see if this helps. Sometimes people are audio learners and they get stuck with the reading, and sometimes you end up reading just a portion, you get bored, you go to sleep. Anyway, so let's just see about this invisible contracts. Thanks, Brian, for posting this, by the way. I better wet my whistle before I start. Okay. In 1910, the Supreme Court ruled that if a prince creates some type of a profit or gain situation in commerce, and remember that king's commerce is a closed private domain belonging to government. I didn't know that. Then the king can participate in taxing that profit or gain that the prince created. So it looks like we're going to be reading pages 482 to 531. Oh, okay. That's not too much. Okay, good. When state-created benefits are accepted by you, then the commercial enrichment you experience within that state franchise is very much within the taxing power of the United States government. And that is correct law. Additionally, the king can tax other state-created commercial benefits that are experienced by others, like attorneys and accountants who, as special interest groups, use the police powers of the state for their own private enrichment. Great. By setting up shared monopolies and then experiencing higher revenues than otherwise obtainable under a laissez-faire free market entry without restrictions on new lower priced competitors entering into their trade. This game of using penal statutes, and I kind of like what Jules said about penal. That was funny. Penal statutes to create shared enrichment monopolies is quite old. And yet look around you today and see how many bleeding heart folks there are who really want to believe that line that government is their friend. Just somehow, and also fall for the fraudulent line that such a monopoly is for their own protective good by keeping all those evil quacks, vile frauds, and assorted degenerate incompetence out of the legal and medical professions. Although we might not be too philosophically sympathetic with the manipulative use of legislatures to create monopolies and the tortfeasance that is thrown at us in the adverse secondary circumstances flowing from their operations as a matter of law, creating game rules for voluntary players in king's commerce is largely immune from constitutional restraints. In France, in the 1600s, Finance Minister Jean Colbert once wrote a code of commerce, sometimes called the Code Savary, 1673. Savary? I don't know. The code created controlled entrance guilds. Oh, and laid down rules for apprenticeship. Oh, and admissions of masters. Oh. An extensive number of trades were so regulated by the code, and once entrance into those guilds was restricted, example, the number of possible competitors was restricted, then the demand for taxes immediately appeared. Each new guild was to pay certain sums for the granting to it of statutes and regulations. Colbert raised money from the organization and reorganization of the guilds and made of them, before the century was out, congealing monopolies, which the state wanted because revenue could be raised from them. As a general rule, money-raising statutes that generate enrichment for the crown never die. And down to the present day, a portion of the commercial law of France remains based on the 122 articles of Colbert's Code of Commerce. But here in the contemporary United States, once a state has got you tied into a licensing program of some type, then and there you are experiencing some type of state-created juristic benefit. And as such, you then become a federal taxable object for this benefit, accepting reason alone. When presented with such a state license, no other questions about the existence of the national citizenship contract or any other juristic contract ever need be asked by those termites in the IRS searching the countryside for some meat to lay into. Other state monopolies like driver's licenses and motor vehicle registrations are very much used by the IRS in many ways to assist them in tax collections. And state tax collectors also use these records for their own statute enforcement and state treasury enrichment conquests as well. When those driver's license records are collected by the state, they are also forwarded to Washington and then redistributed to foreign persons and foreign political jurisdictions under numerous executive agreements, diplomatic and military treaties, and bureaucratic cordialities. Yet, even though you entered into those state licenses merely to avoid your incarceration as an unlicensed driver, the uncontested preparation of a state-created juristic personality, such through a driver's license to the Supreme Court, would be prospectively sufficient for that court to attach in personam liability to Title 26 as a person accepting special state-created benefits. Title 26 is where they get the IRS code right there. It is also reasonable to infer that a driver's license is evidence of residency. Yeah, that's true. And of the acceptance of a wide-ranging array of state benefits tailored to residents. Remember that your use of those highways is your acceptance of a benefit that government created. Yeah, but you're not doing commerce on it. You're not making money going on the highways. And since reciprocity is expected back in return, contracts are in effect, invisible and automatic. No, I don't think so. No, this is my private conveyance, my home goods, and I'm not operating in the same venue as you, Mr. Traffic Services Officer, making money on the highway. I'm not doing that. If you do so, file objections to the assertion of a benefit taxable juristic commercial status. Benefit taxable juristic commercial status over you by way of a driver's license, you will need to again prove your present state of mind. And the exact state code criminalizing such innocuous behavior has to be quoted within the body of your objection. I'm not an employee of the state. This traffic code for motor vehicle doesn't apply to me. Some folks prefer to play it safe and avoid the driver's license altogether, while others selectively use deception in assuming a nom de plume for purposes of deflecting recourse identification. A nom de plume for purposes of deflecting recourse. Is that a name of something? I don't know what that de plume means. Another identity. However, other folks are not able to so quickly terminate the driver's license due to the fundamental importance of the thing and either their present inability to successfully handle a criminal prosecution, or their reluctance to assign something deleterious to it. Is that like something to delete? I don't know. And so at a minimum, an objection and a declaratory judgment to quiet status originated in federal district court is in order. Oh. So at a minimum, an objection and a declaratory judgment to quiet status originated in federal district court is in order. The declaratory judgment ruling that the driver's license was a compelled license, that's kind of true. Existing as a coerced instrument signed by you to avoid incarceration as an unlicensed driver, and is not to be used by the IRS or anyone else for the expansive purposes of evidence of either residency or of domiciliary, you know, where you domicile, nor as evidence of entrance into commerce or of the taxable acceptance of federal or state created benefits, or of consent to be bound by any statute other than those state motor vehicle statutes. The objective of our pursuit of a declaratory judgment is that since the license was compelled out of us when some de minimis tension is in effect with the substantive right, the right to travel, and since the avowed purpose of the license itself is to adduce evidence of competency, then the extraneous, boy, there's a lot of big words here, extraneous collateral expectations of reciprocity in any area outside of those motor vehicle statutes it would otherwise create when left unchallenged is now terminated. Okay, wait, I need to understand that again. Okay, the objective of our pursuit of a declaratory judgment is that since the license was compelled out of us when some de minimis tension is in effect with a substantive right, the right to travel, and since the avowed purpose of the license itself is to adduce evidence of competency, you passed the driver's license, here you go, then the extraneous collateral expectations of reciprocity in any area outside of those motor vehicle statutes it would otherwise create when left unchallenged is now terminated. I still didn't get that, but I'll listen to it again and maybe I will next time. If you are going to object to, maybe this is explaining it, and have new narrow contours now defined on your driver's license in order to restrain its use by other government agencies as the high-powered king's equity attachment instrument that it is, then the objection should generally follow the model pattern set forth above in the discussion of the Federal Reserve Notes. This objection should refer to the exact state penal statute that you are applying for the license under objection and protest merely to avoid incarceration as an unlicensed driver. Remember that the Supreme Court is in Washington and you are out in California, Florida, or Texas. And it is unreasonable for you to assume that the Supreme Court knows the state statute that you are objecting to. So quote it for them verbatim, exactly how it says. How can you engage in involuntary behavior based on threats contained in a state statute if you don't even know what the statute says? If you are just too busy to go down to the law library, which I guess you can go online nowadays, and find out the exact wording of that penal statute, I have no sympathy for any rebuffment that you will experience later on as some appellate form rules adversely against you on the grounds that your state of mind was not clarified substantially or timely. Also included should be a brief recap of the right to travel cases in the United States Supreme Court. Patriots and highway protesters are reaching incorrect conclusions when they cite the right to travel cases as being sufficiently substantive to annul state statutes requiring highway operators' licenses. Right, but if we don't work for the state, I mean, I guess if they're making you a shadow employee of the DMV or the state of whatever, your state, are they saying that we are state employees and that we're operating, being paid to drive a motor vehicle? Those are the things, those are the words. Those right to travel cases only offer a line of reasoning parallel with your objectives. Only in loose dicta does the reasoning found in the right to travel cases support your position. So they offer a mitigating source of relief against state statutes, but not a necessarily vitiating source of relief. Relief, equity, that's what I want. Nowhere did our founding fathers restrain the states from requiring licenses to operate motor vehicles. Yeah, well, motor vehicle, that's the word. This person right here is using motor vehicles, but if it's our automobile, it's not a motor vehicle. Motor vehicles for hire, I'm just saying right here, boom. Or anything else on public highways. And the words right to travel do not even appear anywhere in the Constitution. Well, we do have rights. Well, and the Constitution is for those people who did swear an oath to defend it. It's not like it's our Constitution, which, by the way, I think we should write our own Constitution. I have the right to travel in my own private conveyance, which is on my own private property, which I claim on a UCC one. Hey, and although the words right to travel do not appear anywhere in their Constitution, the Supreme Court has, through their opinions, like as if they're God, hello, because they're not, given that right constitutional status cognizance. Yeah, well, I'm just saying, I never swore to protect the Constitution. Okay, so I did when I was 17 and I was in the military, but that was a lifetime ago. Just saying. But, you know, I'm just saying, this person right here is talking about stuff. He's mixing things, this one right here, George. But whatever de minimis protective penumbra, the right, he likes to use a lot of big words, the right to travel cases offers, the penumbra, the protection. You are now invoking to abate both your regional prince and the king's tax collectors, who use Department of Motor Vehicle information. Well, if you don't have a contract with the Department of Motor Vehicle, can you prove your truck? Can you show me the contract, please? And legal assumptions that information infers for their own enrichment purposes. That's right. In this circumstantial context of submitting a carefully pre-planned and prepared written objection where time is not of the essence, failure to cite your authorities, failure to explain your justifications, timely could be fatal. Yeah. You are up against high-powered adversaries. That's true. And lightly drafting papers as if you were on a picnic is fatal. Yeah, I understand that. Judges do not owe you justice aligned with your philosophy. Well, I suppose you could say it's your religion or your religious, stuff. But those are adversary court proceedings you are in. That's true. Those aren't like real courts. They're administrative tribunals where mere preponderance wins. I know. I've been there. And in substantive objection is open to attack. 'Tis true. And remember that a right to travel also lies outside of and beyond the reach of the King's Charter, the Constitution. Wait, let me just understand what he's saying in the parentheses. Remember that a right to travel also lies outside of, and beyond the reach of the King's Charter, the Constitution. Right. That's what I'm standing on. I'm just saying it's my religious exemption given to me by God. I have a right to go places. I'm just saying. So yeah, we're in agreement there. Some judicial forms from another era have applied the Liberty Clause. Liberty. That sounds like we're getting a permit to be able to have liberty there. Clause in the Fifth Amendment to restrain the interference by the federal government in the right to travel area. But keep in mind that those cases were ruled upon in an era when automobiles and other high-powered technology did not exist in the United States, and highway contracts with states did not exist then as well. But even though our automobile is not called a motor vehicle, by definition, two different things, because the motor vehicle one is the one that, you get paid to drive that and to operate that one. And we're not making money on the highways. So this guy, he's not, how old is this thing? Come on. 2009. Okay, yellow. There's some holes in this thing. So your objective in having the contours of the driver's license. Yeah, I'm not a driver. I'm not being paid. I fired myself. Restrained to now apply only to highway contract grievances. The right to travel being claimed is both of a constitutional origin. Is it? I thought you said it was outside of it, as well as of a natural origin. That's right. It's natural origin. Oh, okay. You're saying I have rights of the Constitution, but that's the 14th Amendment U.S. citizen, isn't it? Or the one who's sworn to, protect the Constitution. I still say it's the natural origin, ex-constitutional, 20. But important for the moment is the objection itself. And your declaration, I'm going to say out of your mouth, therein that you are not a resident. I'm not because resident means you're living in Washington, D.C. and living somewhere else temporarily, or a citizen of that state together with correlative supporting averments of benefit rejections, regardless of any statute that facially appears to force residency status on persons. Come on, persons. We're not persons either. Physically inhabited in that state for an extended period of time. He's really mixing a lot of different words. It really does help to know the definitions of all these words, huh? But if your objection does conform to this model, then a judge generally will be reluctant to hold the spurious, unrelated reciprocity terms of a commercial contract, which driver's licenses can be applied to operate as a commercial enfranchisement instrument under some limited circumstances against a person in a setting other than the originally specified terms, who has proved that they entered into that contract under compelled circumstances when they were 15 years old, getting their permit, in order to avoid incarceration, merely to enjoy a substantive natural right, the right to travel, and without experiencing any commercial benefit therefrom. That is the type of an objection the Supreme Court wants to hear. The documentation and proof that the Supreme Court would want to see is a copy of the application for the driver's license where it says you signed it under protest. Oh, that's good. So we can do that. Signing it under protest. Oh, that would be good. Cool. Proof of service of your objection on state officials. Okay, proof of service, that would be that green card from the post office, you know, to show that certified mail. Or would you be doing it with registered mail? I don't know. On state officials, the objection itself, and a 30-day invitation to those state officials to let them cancel. Oh. Or rescind the driver's license if the application of commercial status and or residency status is deemed mandatory on all license holders, thus requiring those state officials to come out of the closet and expose some status-oriented law to you they might not want you to know. Under your declaratory judgment, the driver's license will be construed to act exclusively as evidence of competency under motor vehicle statutes only. If they do decide to rescind, this is a classic case for administrative law intervention, and in either alternative administration disposition, you win. Wait, let's read that again. If they do decide to rescind, okay, this is a classic case for administrative law intervention. And in either alternative administration disposition, you win. Here, our administrative grievance with the state concerns the disputed commercial and enfranchised residency citizenship status that your driver's license will otherwise be judicially construed to convey in the future. Uncontested driver's licenses can very much be used by state taxing commissions as evidence of residency, and hence evidence of an in personam attachment of liability for the expected reciprocal payment of benefits accepted on the state income tax, among many other juristic things. I never knew that there was a benefit of state income tax for driving. Are they talking about the mileage? Is that what they're saying? Trying to say? I guess so. As viewed by sophisticated appellate judges, for state vehicle code enforcement purposes, driver's licenses are evidences of an operator's competency and are not, in this context, the evidences of consent to be regulated in commerce that highway contract protesters occasionally talk about. The state does not need any driver's license from you in order to force you into an administrative contract when you accept the benefits of driving a motor vehicle down a state highway. That's why we rescind the driver's license. Hello. Patriots propagating the view that the mere existence and non-existence, I guess I'm a patriot, oh my God, and non-existence of a driver's license attaches and detaches liability to those state highway regulatory statutes are misleading their followers. Okay, well, let's see what we're saying. You don't need any written contract on someone in order to sue someone and bring him into a court and perfect a judgment against the poor fellow. But you do need to show the acceptance of benefits and of the expectation of reciprocity, which elements are very much present when a motor vehicle, there's that word again, we know motor vehicles for hire, is operated. That's another word, operated. That means someone's being paid right there because you're operating something that's for hire on state provided highways. Get out of my face with that. On state provided highways. Get real. We're allowed to go places. Hello. With public notice. Statutes creating the expectation of reciprocity. I put a sticker on my car. Under this setting, it might be preferable to move directly for a judicial declaration of status rather than pursuing administrative estoppel remedies. The declaratory judgment is important protection material for you in other non-related areas of taxation, and you have a good chance of getting one issued out. And so submission of your case to a sequence of state administrative law procedures, that doesn't sound good, in hopes of using collateral estoppel abatement arguments later on, might be discouraged in this instance. Federal judges will be reluctant to listen to California Motor Vehicles Department administrative law questions in an IRS case of some type, even though the judge knows very well that there is some peripheral merit to what you're saying. And so all factors considered, jumping to a declaratory judgment becomes appropriate by necessity in this unusual factual setting of redefining the contours of an adhesion contract driver's license to a limited and narrowed construction, meaning evidence of highway competency only. Boy, this guy's like mixing stuff, man. I don't like that. One of the evolving stages, and it is definitely evolving, isn't it? In the life of what are now contemporary penal motor vehicle statutes had, as one of their previous stages, the purpose of assigning legal rights and liabilities to motor vehicle operators, those are those driver people that make money, so that civil litigants can have fault and damages assessed against them in a courtroom. Like insurance. For example, in Massachusetts, it originally was known as the trespasser on the highway doctrine and later evolved into a regulatory jurisdiction when Massachusetts enacted a comprehensive Motor Vehicle Act after automobiles made their highway appearance. Motor vehicle is different than automobile, though. That's what my contention is. The talk from patriots and highway contract protesters that I hear constantly about how the old common law says this and that about my rights to use government highways any way that I feel like it is actually not relevant today in the United States. Okay, give us your point on that. Reasons. First, the factual setting that our father's common law on free ingress and egress developed out on the king's highways is not replicated today in the United States since technology. Get real, dude. No, sorry. It's all about renaming the motor vehicle and automobile. I'm just saying, because we're looking on the Black's Law Dictionary and it tells you, I'm just saying, but we'll keep reading. But I'm just not, whatever. Since technology has changed the factual setting that our father's common law used to operate on, contemporary technology has very much changed the quiescent horse and buggy era. Shut the and pedestrian highway factual setting our father's common law grew up on. Sorry, I don't agree. In the old horse and buggy days of England, shut up. This guy, who is this? This guy is a controlled, who is this person? I don't like this. Highways were largely dirt paths. Shut up. It's got nothing to do with this. It's got to do with commerce, dude. Acquired from the easement forfeiture from adjoining landowners. Here in the United States, up until the 1940s or so, there was an extensive network of privately owned toll roads. Okay, well, that's not around here. I'm just saying. Government was just not into highways that much. In Old England, shut up. We're not talking about Old England. We're talking about America. The king never spent any money on those dirt paths called highways, as there was nothing to maintain. So when foul weather, yeah, potholes and taxi cab, yeah, I get it, all those commerce people. Even adverse weather lasting across my entire season made its appearance. Then the road simply ground to a standstill and nothing moved. Okay, this guy, so far, I'm not liking him. But today, government is spending incredible amounts of money. Yeah, using COVID money, fake money for, improving stuff while everybody's in their house, year in and year out, to build and maintain highways. Yeah, so right to travel argument parallels that folks draw that try to disable the contemporary ability of the king to even ask for reciprocity back in return for benefits offered are incorrect. I don't agree with you. Since in the old days, the king was not offering a special benefit to begin with, except in some London streets constructed with cobblestone. Oh my God, shut up, dude. And so to say that the king was once disabled back then from, do I want to keep reading? Because I don't like this. This is stupid. And from asking for reciprocity when the king never initially provided any benefits is an incorrect parallel built upon disparate factual. So yeah, you've listened to too many lawyers, dude. Wait, do you have a bar card, dude? Who are you? Who is this that wrote this? George something. And today, high-powered technology routinely causes wholesale death and destruction when an operator, that would be somebody who's getting paid, by the way, does no more than momentarily lose absolute mental concentration on driving, which is for hire. And in such a factual setting, an honest assessment by highway contract protesters, that would be me, of the underlying legitimacy of the requirement that there be evidence of competency. Okay. Yeah. Having a driver's license and being competent, revoking them doesn't mean you're not competent anymore. It just means you have woken up. Would necessarily result in the conclusion that a driver's license, so-called, really isn't all that unreasonable. Shut up. Do you work for the DMV, dude? I'm just saying. Are you a driver? Are you making money? And is in fact very reasonable. This is like controlled opposition here. So it is technology that is responsible for the Prince's Highway Lex and not the traffic density. I can't believe it. This is Fam Guardian, published author Mercier George. I'm just saying, dude, congestion that is created from the mere existence of other people in society, whatever. I don't know. Density congestion that is created from the mere existence of other people in society. An interesting and very strong argument can be made by your adversaries. Okay, I'll listen to what you have to say. Arguing that it would be the failure of the states to preemptively regulate the highways by licensing. Well, that's what they're trying to do. They're trying to get rid of driver's license because they're wanting to do some type of, I don't know, other state licensing thing. Smart. I don't know what they call that thing. Yeah, because they want you to have a bill to prove residency. That's what they're trying to do. Get rid of the driver's license. I know that. Licensing that interferes with your right to travel. Since having physiologically incompetent drivers out on the highways obstructs and interferes with the right to travel of those other drivers who are competent and not being paid and stupid for having a license. And your adversaries have a truckload full of statistics to support their line of reasoning, which, hey, we already looked at the definitions and they're doing, what is that thing called? Plausible deniability. So, dude, you're like not even our friend here. I'm just saying. Do you see what a difficult corner clever insurance companies have worked judges into? Yeah, that's another scam. Their arguments are logical and coming up from a factual setting steeped in the presence of jurisdiction. Yeah, come up with a bond. Have a bond then instead. You don't need insurance. You can have insurance or a bond. Get a bond. Great weight will be given to their arguments, no matter how self-serving, twisted, or vicious they may be. Whenever anyone, regardless of your relational status off the highways, uses those government highways, I'm just saying. So now they're the government highways. Now they're not for the people. You're saying it's the government. Who's using our money, by the way, and the gas tax and all that to build them for us. Now they belong to the government, do they? Okay, I'm just saying. An invisible contract is in effect right then and there. Whatever. It is not necessary for your regional prince, the state, to adduce written evidence of your consent, just like it is not necessary to get a contract in writing to get the contract enforced judicially. When protesters get up in the morning, get out the old car, this guy is mocking us. I don't like this guy. And drive into the street. They're literally driving themselves into a contract. No, because you're misusing the word driving, dude. Just saying. If we're not being paid and we don't have a contract with the DMV, then I'm just saying. As the protester then, and their accepted benefits conditionally offered by the state, why? By signing up with the DMV? Nowhere in your state constitution does it require the prince to build and maintain those highways of his. So his building and offering those highways for your consideration and possible use is purely discretionary on his part, nor is your prince restrained from possessing any expectation of reciprocity from persons. Really, from persons? Are you using that word persons? Like, what would persons be? An entity? A corporation? Not a people? Accepting the benefits. Yeah, well, that's because it's the person. Accepting the benefits derived from the use of those government highways. Yeah, it's not commerce. We're not doing it commercially and we're not getting paid. That's what I'm saying. I'm maintaining that. So our fathers, who's our father? Are you my brother? I don't think so. Who is our father? Old common law isn't being contaminated at all by Star Chamber traffic court judges, ignoring the fact that no tort damages were caused by the criminal defendant. Excuse me, could have sworn that you need a license to do something that's illegal. If you need a license because it's illegal, I'm just saying. As they go about their work prosecuting technical infractions to highway contracts, because neither of the twin tort indicia of either mens rea or corpus delicti, why isn't he giving the regular people, mens rea is like when you're going to do something to harm somebody, or corpus delicti is the injured party. Why isn't this dude, he's using all these big words, why isn't he given the definition right with his stuff? Talking all big. Penal dude. Deficiency arguments sounding in the sugar sweet liability, vitiating music of tort law that highway contract protesters love to throw at traffic court judges. They're not judges. They're administrative tribunals and they're employees for traffic services. Just telling you. We have some different definitions that we have to go over here, Mr. George, are not even relevant whenever contracts are up for review and enforcement. They never have been, and they never will be, and the last day before Father will not be any exception. What the heck are you talking about? Who's Father? Who's Father, dude? And the last day before Father will not be any exception. Who is he talking about? The Pope or something? Who's Father? Many folks out there are searching for a silver bullet. This guy is mocking. I don't like this thing. He is mocking. I'm just saying. I hear references to that perennial search constantly. He is a piece. This guy is, I'm just saying. I don't like this guy. They are searching for some legal procedure. I don't like this guy. Excuse me. Some great airtight line of reasoning. Some great legal brief that just ties it all together to throw at the IRS. I don't really know what the IRS has to do with this. I mean, I guess if we're going to do a 1099 cancellation of debt on these traffic services, then I guess the IRS is going to be involved. These folks are missing the boat. Really? You're saying that the ones who are knowing how to read are missing the boat and know about definitions are missing them? Really? Dude, George, I don't like you. So to speak altogether, because the origin to their frustration lies in invisible contracts. Yeah. I don't see anything. I don't see any contract. Show it to me. Can you prove I have a contract? Show it to me. It looks pretty invisible to me because I don't see nothing. I'm going to have to prove that there is something. Yeah. Like, show me where I have a contract with the DMV that I'm licensed, and show me that I'm being paid to operate as a driver, a motor vehicle. I'm just saying, hey, if you're going to have your definitions, we're going to have ours too. And we already know your definitions because we looked them up. I'm just saying. And you become a party to those invisible contracts because you accepted some benefit someone else was conditionally offering. Really, what benefit is that? I mean, would that be like AAA? Because, you pay for AAA so they can pick you up on the side of the road. I guess you'd have to show their driver's license, or you could show their SPC, non-driver, non-US citizen. Yeah. And for some philosophically uncomfortable reasons, the reciprocity on your part that the contract calls for is never forthcoming. Even walking into a shopping center could be a contract. Yeah. If the management so much as post a notice giving some conditional or qualified use to persons entering therein, you mean like wear a mask? If you don't, no service, and accepting the benefits the management is offering, such as requiring shoes and shirts and masks. And so are the arguments of unfairness, that those reciprocal terms of wearing shirts and shoes just don't apply to you because you traveled from just so far away. What if you were in an accident and were bleeding and you need to go buy a shirt and you need to buy some shoes? I'm just saying. As some shopping center security guard throws you out of the place, is just whimpering. It is actually the continued refusal by protesters to first see and then honor. Yeah, well, I have to go to equity chancery court, dude, because this is not right. Invisible contracts that creates the friction that irritates protesters so much. Dude, seriously, you're mocking. I don't like you. And the silver bullet you protesters are looking for, actually lies within yourself. Yeah, what are you saying? Remember that your use of those government highways. I don't like you, George Mercier. Dude, because you didn't look up the definitions. Who says that they're government highways? Government highways? Hello, I'm just saying. Is your acceptance of a special benefit? No. That government created? No. We're talking about commerce, making money. The person, all caps, is an entity. Maybe because it's illegally trespassing on Admiralty because of the net being thrown. Is that what it is? And federal government's thrown a net over everything. Is that what you're saying? And since reciprocity is expected back in return, is it? Contracts are in effect. I don't think so. Automatic and invisible. I don't agree. And one of the ways out of a contract altogether is to prove failure of consideration, meaning that you did not accept any benefit the other party offered. That's the one I'm going with. I'm just saying. Just how does a person prove failure of consideration when he was caught accepting a benefit by driving down a state highway? Okay. Person driving state highway. That's those legalese terms. I'm just saying. The right to travel cases really don't support the position of you protesters very well. See how you see? The sky is against what we know. However, there is some merit in your harmless expression of political dissent. even if the dissent is technically improper. Addressing the argument specifically, there is simply no statement anywhere on the right to travel cases that bluntly restrains the states. Yeah, how about look at the vehicle code? Who does it pertain to? Employees of the state. Duh. Bam. Where's the mic? No state shall require licensing as a condition of use of public thoroughfares. Oh, that sounds good. No state shall require licensing as a condition of use of public thoroughfares. That sounds good. And since our founding fathers never restrained the states in this area, then snickering at judges today who are writing on a record that does not restrain expectations of reciprocity is improvident. That somewhat tranquil era of horse and buggies. Shut up. It's got nothing to do with this right now. I'm just saying. No longer dominates the highways. Duh. I almost stepped in horse shit though on the street because over here they got horses. I'm just saying. Where in its place today lies the high-powered automotive. See, this guy is just making me mad. I'm just saying. And also gone from the scene is our father's old common law. Oh my God, how much do I have to tolerate this shit? On basic property rights, the right to clean air uncontaminated by automotive exhaust. Oh, now you want to call it automotive? I thought it was called motor vehicle. Make up your mind. Because you don't have to get a smog check when it's not commercial. Did you know that? Dude, you're mixing stuff. What? You've got to be a spinning globey. That's what you are. And you think we landed on the moon. That's what your problem is, dude. Which is also taking the backseat. Oh my God, how much more of this our founding fathers brought? Never restrained the states from asserting regulatory jurisdiction over public government. Highways through an operation of contract. By comparison, the framers were also negligent in making sure the First Amendment was applicable to all potential future forms of communications media that an organic technology would bring forth someday, because the First Amendment, frozen in the hard paper media technology of the 1700s, does not apply to restrain the establishment of a regulatory speech and content. Yeah, it's because you changed the definitions. Yeah. Look at all those different Black's Laws dictionaries, and you guys change the definitions of marriage now. Used to be one man and one woman. Now you can what? Marry whoever you want. Next thing is going to be how many people can you marry? And it's going to be your animals next to. I'm just saying, you guys keep changing. You Babylonians. Supervised jurisdiction over television, yeah, and radio media, propagating through the electromagnetic spectrum that the king grabbed for himself by his radioactive 1927. And in other areas, technology has eaten away at what would have otherwise been not permissible under the Fourth Amendment. Today, in similar ways, the Fourth Amendment is being hacked apart in ways our fathers never even considered because of the technology existing today. Aviation flights and electromagnetic scans did not exist then, so no such restraints were included in their writing of the Fourth Amendment. Dude, this is one of those guys that wants to get rid of the Constitution and all that stuff. I could tell you just by reading his stuff, rather than snickering at judges today. Didn't you say that earlier? You said that earlier. I know you did. Did I just go back? You said that earlier, rather than snickering at judges today. I could prove it if I scroll back. You said the same thing. An accurate assessment of the origin of the problem is that our fathers lacked the sophistication required to apply worst case scenarios over the likely geometry of government, and failed to preemptively apply their majestic restrainments to apply to prospective but then unknown technological innovations. This guy is off point, big time, off point. Yeah, he is. Yes, the Constitution was inspired, but an inspired document is not a perfect document. Look at how he is. Do you see? This is the type of guy right here. Boop. I got your number. You Democrat, and you want to get rid of the Constitution. Inspiration only means supporting assistance and not control. And you probably, I don't know if you even believe in the creator. But remember that the question of damages or no damages is a tort law factual setting question, and it not relevant. It not relevant when you are out on those state highways because a contract is in effect whenever you use those highways. No. Dude, your witchcraft is just not working for me. I'm just saying. By your acceptance of benefits offered for your use conditionally, when you operate a motor vehicle over those state highways, look at how you are trying to steal, kill, and destroy by renaming and relabeling stuff. And I don't appreciate you, George. You have accepted special benefit. This guy, was he a lawyer, this guy? Who is this guy? Because I don't like him. Created an offer by the state. Yeah, and so accepting juristic benefits in the context of reciprocity being expected back in return. Then there lies a contract, quietly invisible, automatic. Brian, do you seriously like this? Because I don't. I don't like this. The relational, non-commercial, non-resident, and non-citizen status. Hey, I didn't say nothing about non-citizen status. I mean, you know, we're talking about a state citizen of the operator off of the highway is irrelevant in attaching contract liability by itself. Yeah, I'm really tired of being brainwashed having to read this crap. A specific on-point adjudication on this driver's license question is going to involve this question: whether the states have the standing jurisdiction required to force under penal statutes. I don't want to look at your penal statutes. They're ugly. A regulatory jurisdiction such a contract creates when tension is in effect between the existence of that contract and the substantive right to travel interest discussed in appellate rulings. In every recent state court ruling that I've examined post 1930 era, where a quo warranto type of question was being addressed, all courts forced a regulatory jurisdiction over the operator of a motor vehicle. That's the ones who are getting paid, right? And pleas and cries for restraints based on right to travel and right to work, tensions and the like have all universally fallen on deaf ears with state judges in this era. That's because those probably weren't real judges. I'm just saying. And also by federal judges. Federal, isn't that like Washington, D.C.? Just saying. When addressing questions of civil rights. Civil? Is that civil law like Roman law? Violations, relief when highway contract protesters throw vindictive Section 1983 actions at some traffic cop. Yeah, for traffic services. Just saying. Yet, despite this predominant skew toward contract priority and judicial right to travel doctrinal reasoning, yeah, this guy is not for him, I'm just saying. Annulment by the Supreme Court of Criminal Liability for the innocent use of public highways under circumstances where no collaborating damages were caused would be appropriate. An honest assessment of the total factual picture by a sophisticated judge would result in the conclusion that merely driving a car down a street without a license does not ascend to the minimum threshold requirements that characterize legitimate criminal incarceration standards. Compelled contract or no compelled contract, those penal highway statutes exist by virtue of special interest group, sponsorship, and pressure. Who are these special interest groups? Are you talking about like the Judicial Council of the states that are a bunch of lawyers and judges? Sponsorship and pressure? Police? Who? and judges are diminishing their own stature and violate the restraining mandates inherent in the Republican form of government clause by letting clever and politically ambitious special interest groups get away with whatever they can by in legislatures to damage innocent behavior under circumstances where unnecessary covenants within adhesion contracts are being asserted in tension with substantial natural rights in the locomotion area. Other highway drivers have no assurance that another approaching car is not being driven by an unlicensed citizen of France. Oh, this guy's French. Oh, Mercier. Oh, okay, that's that guy. He's over there in France. Okay. Who, by virtue of his political status, would not have. Do they have a king in France? The King of France. Oh, maybe they do have a king in France. Who, by virtue of his political status, would not have an unlicensed motor vehicle. Dude, you got to read like freaking Black's Law Dictionary. Keep saying motor vehicle driver and stuff like that. Dude, you don't even, whatever. Therefore, there is an inherent assumption of risk among all highway users that some drivers will necessarily have to be unlicensed, since it is literally legally impossible and also unattractive for foreign relations reasons not related to preventing vehicular accidents. That's why you have a bond. And how we access that bond, I do not know. But look at that birth certificate thing. Hey, there's a bond. Saying use the exemption number there, social security number. And yeah, to maintain a perfect expectation of motorist licensing compliance. Yeah, these risk elements on using highways are judgment factors that all motorists evaluate and consider, even though this process is often invisible by operating in the psychological strata of the subconscious. Whatever. Actual judgment process involved when a composite profile confluence of such risk elements are blended together. You mean like the globe, like land, water, and air are a globe, a spinning globe at that chase the sun? Is that what you're talking about? Because you just keep conglomerating everything here. And evaluate it is called a risk assessment. In a factual setting where an unlicensed driver, you have to have a license to travel. Just saying. Creates damages out on the highway, then punitive incarceration is appropriate, is it? How about if you pay for it? How about if you make it right? Do no harm. And this requirement reconciles everyone's objections by accomplishing the same identical criminal recourse. The incarcerationists yearn for so much in their vindictive cries for engagement glory. This guy, it's too much. Using big words and not even putting the definition. Get real. Incidentally, by comparison, in Canada, the Ontario police only seeks a $53 civil fine for driving without a license. And the sky doesn't seem to be falling in on Canada without the existence of some precious little penal statute in existence to incarcerate an unlicensed drive. So case-hardened American judges who parrot the insurance company lobbyist line that incarceration is the only medicine to deal with an unlicensed driver. How about paying for it? Stupid asses. Is there some money on that driver's license? I just want to know, is there insurance on that? Cash it. Use that money. I mean, hey, isn't it tied to the social security number? I think so. And you got your address? Yeah. Or exercising flaky judgment that isn't very well thought out. Duh. Law says I gotta. Oh, I didn't even really finish reading this. I think it's almost done though. Even prominent United States Supreme Court judges can be found operating in this competency limited strata. as they live in a shell, isolated away from divergent opinions that may very well be built upon a large basis of factual knowledge they do not possess, and as such might possibly have some merit to them. This highway power play by insurance companies to use penal statutes and the police powers to experience commercial self-enrichment, I like this part, raises a secondary fairness question on the propriety of using statutes operationally skewed to favor their sponsors. This is some good dirt right here. However, fairness is a tort concept definable only along the infinite. And in contrast to that, contracts are narrow, specific, and contain detailed positive mandates and negative restraints in effect between the parties. Being that contracts are both specific and finite, and that special benefits were accepted synchronous with the contract's technical reciprocal contours being predefined. Therefore, the inherently indeterminate nature of fairness is fundamentally out of harmony with contracts and properly belongs in that freewheeling world of tort law where anything goes, where the terms of contracts are not freely negotiated due to the dominant overbearing positional strength of one of the parties. This guy is in love with his verbiage. The judicial allowance of a de minimis amount of corrective fairness is appropriate since there never was any mutual assent, and that already exists in American jurisprudence and is now called the adhesion contract doctrine. 55. Okay, I'm up to 55. How much longer is this going to go? I just need to see. Where is it? I'm on 55. I just want to see how far more of torture I have to read. Because this is torture. I don't like it. Oh my gosh, no way. I got up to 55. If somebody else wants to take over, they can. Because I am just so sarcastic in my reading because I am not liking what I'm reading. So I just thought I'd go up to 55. Someone else has to take over, okay? Because I'm done with this dude.